and Justices of the Supreme Court of Michigan. All persons having business before this honorable court are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States, the state of Michigan, in this honorable court.
Good afternoon. This is the afternoon session of our October 10th arguments. We have three cases. Again, in cases of the sort that we have this afternoon, there'll be 15 minutes argument for each side. You can waive any free fire zone if you wish to do that. In the third case, Ozimek versus Rogers, it's my understanding that we only have one party here, and that's the appellant, and the appellant will have 7.5 minutes. Let's begin first with Dillon versus State Farm Mutual Automobile Insurance Company.
Good afternoon, Your Honors. Paul Hudson on behalf of State Farm. Your Honor, I'd like to reserve 3 minutes for rebuttal.
That's fine. But keep track of it, please.
Yes, Your Honor. Your Honors, the plaintiff filed her lawsuit against State Farm more than 4 years after her accident, and the issue on appeal is whether her claims are barred by the 1-year statute of limitations. And that issue turns on whether she provided written notice of injury as provided in the No-Fault Act within 1 year of the accident, which would extend the limitations period. And for two reasons, Your Honors, the answer is no. First, she provided no written notice at all. Her notice was oral only. There was no document in the record sent to State Farm that contains a description of any injury to her hip, back, shoulder, or anything else. Written notice means written notice, and her oral notice could not possibly extend, could not meet the statute's requirements to extend the limitations period. And second, Your Honors, even her oral notice described injuries to her shoulder and back, but that's not the injury that she is seeking recovery of benefits for in this lawsuit, not the injury for which she's trying to extend the statute of limitations. The statute provides that her written notice of injury has to indicate in ordinary language the nature of her injury, and the natural reading of that is that it required her to describe the actual injury that she's seeking recovery of benefits for, that she's seeking to extend the statute of limitations for, and not some other injury. So her notice of other injuries did not extend the limitations for her claim at issue here, and therefore her claims are barred by the statute of limitations. Now, and I'll waive any remaining free fire zone that I have. The Court of Appeals.
So on the written notice, apart from whether it was specific enough, as I understand the facts, there was a voicemail left with the agent, correct? State Farm agent. And for years I've given some, on occasion when I deal in my own insurance, I wonder who's this agent represent? Does the agent represent me? Does the agent represent State Farm? Is there some sort of blended version? As I understand it, there's brokers, and I can get a broker to go out and work for me, but an agent generally works for the insurance company. But that didn't really come out in the briefs. Why is it that wasn't developed? The notice was given, and then the agent, whoever that agent represents, filed all of the necessary things under the statute in writing and passed it on to the claim adjuster. Was that agent purely acting for the company? Was it on behalf of, as the words in the statute would say? What is the law on that? And maybe, is that not a non-issue? And if so, why not?
I think the reason it's not an issue, why it has not been pushed in the briefs, is that it's undisputed that she was a State Farm claims representative. Her name was Denise Pierce, I believe.
No, but I understood before Pierce got it from an agent. Is that wrong?
I
the
believe
voicemail was left with the agent. In other words, when I do my insurance with not an independent agent, but a company, and I call that company and I ask for my agent. Tom Jones, my agent.
I believe the notice was given to a claims representative, but I think either way, it is undisputed that whoever they talked to, whoever the voicemail was left for, was State Farm. And under the statute, the notice has to be given to the insurer or any of its authorized agents. And I think the notice was given to the authorized agent of State Farm
So
by a person claiming to be entitled to benefits therefore, or by someone in his behalf.
Was it Pierce that's the claim adjuster?
Yes, Your Honor.
Okay. Pierce was the one that received the voicemail, or somebody else received the voicemail and passed it on to Pierce?
I believe it was Pierce.
Okay.
But I think either way, if I have that wrong, I apologize, Your Honor. But either way, it is the plaintiff's mother, so someone acting in her behalf,
Okay.
calling State Farm.
Who's also the insured, right?
The insured is Mr. Dillon, yes. So if this notice were in writing and it went to State Farm and somebody, either an agent or a claims representative, happened to open the mail that day, I mean, this notice is.
I got it, but a subsequent writing was made, and I guess the question that I'm struggling with is when that subsequent writing was made and passed on to Pierce, and maybe it wasn't passed on to Pierce, maybe Pierce made it herself.
I think the issue there is that is all State Farm, and the statute's plain language says it has to be given by the insured or someone in her behalf to
So if I can finish my thought, is when that writing was made and passed on to Pierce, is there any evidence that was done on behalf of the insured?
No. I think that's done by State Farm only. Under the statute, that would be the insurer or any of its authorized agents. Anybody in that State Farm arena is State Farm.
So when that happens with your company and somebody calls up and they say, I had this problem, and then the agent says, who is the agent of State Farm, says, great, I've got the information, I'll pass it along. Do you think it's sort of incumbent, and is there anything incumbent on the insurer to say, oh, by the way, you'll have to put that in writing, or otherwise you won't be in compliance with the policy or your statute?
I think the way this played out here is a bit unique in that there were never any claim for benefits made to State Farm over the next several years, 2008, 2009, 2010, 2011. And so no bills were submitted to State Farm, no claims for payments.
Didn't they receive something in the mail after the voice that says we've received your claim?
Yes. But there were no benefits sought. In other words, and the reason is that this was a coordinated policy, which meant that when Mr. Dillon signed up for this policy, he said he didn't want health coverage because his health insurer was going to cover that. And so he and the health insurer covered these initial bills, and then State Farm heard nothing for the next several years. But I think it's also important to step back and say there's step one of this argument, which is that it had to be in writing. Step two is that it had to indicate in ordinary language the nature of the injury. And what the Court of Appeals said was that means you can describe any injury. And
we'll
then
stay with the notice first, the written part. That's what Justice Larson asked about, and that's what I'm interested in right now. If there was an acknowledgement of receipt of this claim, and if there was a communication with an agent, and that was forwarded on to Pierce, and then the insured receives a letter saying we received your claim, why wouldn't a person think that written notice had been submitted?
Well, none of that was written notice by the insured to State Farm. And that's what
So Justice Larson asked, wouldn't then the person who received the phone call have an obligation to say, oh, by the way, you need to send us a letter to confirm this, otherwise your claim will never be acknowledged?
The statute puts the onus on the insured to provide the notice.
Why? It says somebody acting on the insurance or in the insured's behalf. Why can't State Farm's agent act in her behalf when it takes down the information?
So the question under the statute is whether someone can file a lawsuit more than a year after her accident. And the statute says the only way you can do that is if someone acting in the insured's behalf sends notice to the insurer that gives written notice of injury as provided specifically in the statute. And so why can it be sort of somebody internal at State Farm?
Who's acting
In behalf.
behalf of the plaintiff?
And I think the answer is because the statutory language clearly distinguishes between the insured or someone in his behalf and the insurer and any of its authorized agents. And all of the State Farm people are acting for State Farm. They're the authorized agents of State Farm. And the statute said it has to be, the written notice has to be given by a person claiming to be entitled to benefits, therefore, or by someone in his behalf. So I think it's the statute that draws that distinction between there are people out in the world.
Can there ever be an estoppel? In other words, they call, and the person on the other end of the phone says, okay, well, we'll take care of this for you. You need to put it in writing, but I'll do that for you, and I'll forward it to the claims adjuster. Could that estoppel, could that stop the insurer from denying the claim then?
No, Your Honor, and I think the reason is because this is a statute of limitations provision, and the legislature has said this is the only way you can file this lawsuit after a year is if you meet these requirements. And
but you can't waive the statute of limitations?
Certainly not sort of incidentally or by accident.
Well, by estoppel, by taking actions that reflect a waiver. So we acknowledge your claim. Could arguably be a waiver of the writing requirement.
I don't think it could be a waiver of the...
Or a waiver of your right to assert that portion of a statute of limitations defense.
I don't think you could have a waiver unless State Farm said clearly and unequivocally, we waive the written notice requirement of this statute and we're going to proceed with this claim. And that did not happen here. What we had was an acknowledgement of a claim of some sort, and then no written notice at all, and then no description of the actual injury that is now the subject of this lawsuit.
Well, counsel, in looking at the various cases published and unpublished, there are a number that disagree with your analysis of what's precisely required by the statute, and they generally tend to have a common theme, one of two common themes the way I see it. One is that the insurer has not been prejudiced in any way. The alternative argument is that the purpose of the statute has not been undermined in any consequential manner. Do you disagree with that analysis? Not so much what the statute says, but do you disagree that you have, in fact, but is it your view that you have in fact been prejudiced by what was done in this case in some manner, or that the purpose of the statute in some way has been retarded or undermined by what's proceeded in this particular case?
Two parts to that, Your Honor. Number one, I think that, I disagree that any of those cases have force in light of this Court's repeated statements that a statute of limitation is enforced as written, that there was no prejudice requirement required, and the Court surveyed sort of the notice requirements.
I understand the textual argument, but that's not really my question. My question is, have you suffered any prejudice, or has the statute been defeated or eroded in some respect?
Yes, the statute would be eroded if any injury sufficed. If you could give notice of any injury within the first year, and then for the rest of your life, years, decades later, not be barred by the statute of limitations and file an action to recover benefits for any other injury. And that's what the Court of Appeals held. And I think a good example of that is actually the CPAN's amicus brief, where they cite an article titled Chronic Thoracic Aortic Aneurysm Presenting 29 Years Following Trauma. And their point is that some injuries lay latent or not diagnosed within that first year. So as a policy argument, that it's sort of unfair to enforce this 1 year restriction. But I think the legislature...
Is there any prejudice from the lack of the writing? I don't know if that was just the Chief Justice's question, but it's mine.
The prejudice from the lack of the writing would be if she had given written notice, she could have spelled out exactly which injuries she was suffering from, and then we could evaluate, okay, what are those injuries?
Right, but if she had said to your agent, so just to isolate the writing question, I suffered an injury to my left hip.
Yes.
And your agent wrote that down.
Then
would you then have prejudice?
Then there would be no prejudice from that.
Okay.
But it's still the legislature's requirement.
Oh,
And that's up to
I
them
understand that. I'm just,
to enforce
Yeah, I
that.
get
But
that.
no, there are certainly scenarios where there would be no prejudice from a writing requirement, and that things sort of proceed normally in any case.
You didn't argue in the Court of Appeals, right?
I did not
No, it
personally.
was a female, because I listened to the arguments. I assumed it wasn't you.
It was not me.
It seemed from the arguments that the only question pursued by counsel was whether the notice of the hip injury. There was no discussion whatsoever of written notice. You know, and opposing counsel has raised this question of whether this written notice, apart from notice of the specific injury, is properly preserved.
And it was properly preserved, and I can give just one example of that in the Court of Appeals brief. In the motion for summary disposition at page 10, and then the Court of Appeals brief at page 9, quote, verbal notification alone is not sufficient. In fact, there are no cases holding that the insurer's own notes based on the claimant's verbal notification is sufficient to constitute written notice of injury.
Was
to
that in the
insurer.
argument section or in the text section? I mean, in the fact section?
That portion is in the fact section, and then in the argument section, at page 12 of the motion for summary disposition, the State Farm argued that only if written notice is provided, and as this did not occur, plaintiff's claim is barred by MCL 500.3145. And I spell that in a footnote as well. There are other places where that is argued. Where it's the problem is not just this specificity of the notice, but whether it was in writing or not.
Counsel, how would your specific body part rule work? How would that work? So if I present with lower back pain and it takes a while, but we figure out later that there is a hip fracture and some kidney problem, does the fact that I, in my ordinary language, called it lower back injury preclude me from coverage for what the real problem was that was causing my lower back pain?
I think it is not an onerous requirement to require somebody to name the body part that hurts and why it hurts. If you go to a doctor and the doctor says, indicate in ordinary language the nature of your injury.
But a lot of people show up in emergency rooms with lower back pain, and it turns out they have a hip problem. That's actually somewhat common. So, and you're thinking not close enough to...
Not close enough, I think, is right. And I think the IAM standard that they announced, or they articulated in their amicus brief, that you described in ordinary language, the part of the body directly affected, head, back, hip, leg, foot, and the principal physical characteristic, whether it's a fracture, cut, burn. I think that sort of encapsulates what we ordinarily mean by describing the nature of your injury. What it would not mean in the ordinary course is if you have an injury to one body part, that you could name another body part, and that would be sufficient to indicate in ordinary language the nature of your injury. And, of course, there are going to be tougher cases where...
If I say leg, does it include knee?
Exactly.
Does it include foot?
There are going to be tougher, could you say lower body injury? And
lower body injury. I like that one.
It's a
That's
hard
what I
one.
would recommend. Everybody say lower body, and maybe upper body, too.
Yeah.
Both my upper body and my lower body feel injured.
Right. And I think that would, my answer to that would be no. That, I hesitate to propose a,
How about a torso injury?
A torso injury, right.
That's a good one,
I think that when the legislature says describe the nature of your injury, that it means something more than, I sort of hurt, or I hurt up here and not down there. That you have to name the body part that is hurting. A back is different than a hip, is different than a knee, is different than an ankle.
Sounds like a new fun area of litigation for lawyers. This could be a lawyer boon.
So how about if the child is injured and the child is trying to describe to their parent?
The statute requires somebody acting in behalf of the insured to describe the nature of the injury in ordinary language. And, I'll point out that, there's a long time to do this, right?
So good
it
luck
may
to
be
you.
the case that you wake up the next morning and you don't know exactly what's wrong with you, but, in the days, in weeks, and months that follow, in the vast majority of cases, you're going to be able to identify what your injury is. And it's going to be the exceptional case where you just don't know at any point in the whole first year which body part is hurting you. And I think that's sort of the wisdom of the legislature's statute here, that we're going to draw the line somewhere, and we're going to require you to identify the injury so that you don't say, I injured my knee, and then 20 years later say, now I have a cranial injury that also arose out of this accident.
So, counsel, first off, good afternoon.
Good
and
afternoon.
I always like to say welcome to the court, and you're doing an excellent job.
Thank you.
But I have a series of questions for you, so I just want you to kind of get comfortable for a second. And what I like to do in a lot of these situations, and the agreement I made with my colleagues is I won't ask more questions on the other two cases, but I am going to focus my attention on you.
You lawyers know 2 cases. It's not true. You can ask as many questions.
Yeah. But here's the thing. I like to look at things in like how it affects real people, right? So I'm going to use my own life experience as an example, and we're going to walk through some things because you're making these arguments, and I just want to kind of go through these with you. So just as a little quick background, I was in a catastrophic injury in New York City. Catastrophic. I was hit by a cyclist in Central Park, and I was in Mount Sinai Hospital for 10 weeks, okay? You're not going to be in a hospital for 10 weeks if the injury is not catastrophic. So let's start walking through what you're arguing before us here today. When you have a catastrophic injury, like let's just use my injuries, and we're only going to take a few of them, but if you've got a crushed hip and shattered pelvis, here's my question for you as it pertains to this. How is this really going to work within 1 year? If you're in the hospital for 10 weeks and you are trying to work through a catastrophic injury, when you're dealing with a hip and a pelvis shattering, the hip and the pelvis affect all the other parts of your body. So let's walk through this. When you're trying to go through your rehab and you're going through your physical therapy and you're doing all the things that kind of come with trying to get your life somewhat back, how are you supposed to identify within 1 year all the issues and injuries that you're going to put forth on that situation? Let me give you an example. You have a crushed hip, shattered pelvis, right? You have chronic, horrible pain. That's going to lead to other things. But the big problem that people who've gone through catastrophic injury is this, is that as they try to move forward with their life, if you have a crushed hip, you're going to have problems that are going to develop later. You're going to have arthritis, and then you're going to have problems with other parts of your body because you're going to have to favor one side of your body. So I'd like to hear your response to that. Like, let's walk through it. Yeah. So when you come out of the hospital after 10 weeks, you've got a catastrophic injury, you're working through your rehab, you're dealing with your therapy. The question I have is that how do you address all of the issues that get arisen from your original injury? So your original injury is a crushed hip and pelvis, but then there's all these other issues that come out of that develop later because of the way you walk or because of the way you do things that are required as a course of daily life, but are leading to other problems with your body that come out of the original injury, but you don't know what those are at the time within 1 year. It takes years.
Yes, Your Honor. I'm pleased to address that. So if you have a catastrophic crushed hip, shattered pelvis in that first year, you, or if you're not sort of in the state to do so, someone in your behalf has to give written notice to your insurer.
Right, but I'm not
that you have, and what you'd say in your written notice of injury is crushed hip, shattered pelvis, right? Mm-hmm. And that's the injury that you have suffered. As to other injuries that developed, let's say, years, decades hence, mm-hmm. I think that was the legislature's judgment to say we are not going to have patients for life arising out of automobile accidents. So if because you were, had to, for example, walk with a cane and then you develop shoulder tendonitis because of that, and you wanted to argue that that arose out of your car accident and your original injuries, I think it's the legislature's judgment that those are just not going to be compensable injuries, that those are barred by the statute of limitations when you file those 20 years hence.
Okay, no, I'm trying to understand your position, right? I mean, I'm not going to argue I'm just going to try to understand I'm just trying to ask the question so I can understand your position. So even if it's clear and unambiguous that your physicians are going to state that this is out of the injury in question, that this is out of that accident, this came out of a shattered hip and crushed pelvis, that you now have problems with your knee and you have problems with and that your feet hurt because you have to drag your feet. Your argument would be that even if that comes out of the accident and out of the injury that we're talking about here, that it would not be covered, that you could not, that even, there's no question it's coming out of, if you have a perfectly healthy person, they get crushed, all right? Now they have these other issues that come out of it. I'm just trying to make sure I understand State Farm's position. It's State Farm's position. So if I'm an insurer of State Farm, I should be aware of this. It's State Farm's position that ultimately anything that's coming out of this injury, so if the pain is coming out of it, all the other things that are coming out of it, even if there's no question, and all the physicians are going to say, yeah, this person was perfect before, this injury is what caused it, and now they're having all these other issues with their feet, they're having problems with their lower back, they're having problems with their upper back, because you can't move your hip and pelvis, your premise would be that's just too bad. Is that my understanding?
Not that it's just too bad, but that the legislature has provided that your claims arising out of this new injury to a new body part for which you did not give written notice of injury within 1 year are barred by the statute of limitations. That is my position, yes.
Okay, no, I appreciate, and that's even if the physicians make it clear that it came out of the original injury.
Yes, that's correct.
Okay, I got it.
And in this case, for example, the jury ultimately did determine that the hip injury arose out of the 2008 accident, and our position is that the statute of limitations nonetheless bars that claim because there was no written notice of injury as specifically provided in the statute. And I think you put it exactly right in the Perkovic decision just a few months back. Quote, therefore, under MCL 500.3145.1, a claim for PIP benefits must be filed within 1 year after the accident causing the injury unless either of two exceptions applies. One, the insurer was properly notified of the injury, meaning the injury for which you're seeking to extend the statute of limitations, or two, the insurer had previously paid PIP benefits for the same injury, and that was the same holding as in the unanimous court in Jesperson, where we're talking about notice of the injury, meaning the injury that you're trying to extend the statute of limitations for.
Okay, I appreciate our back and forth, and you did a great job.
Oh, thank you, Your Honor. And it's a fair question because it does seem like, is that fair or not? And my answer is I think that's the legislature's judgment to make. It's not our role to, judicially say one way or the other whether 1 year is not good enough, should be 3 years.
But
3 years wouldn't have done it here. Maybe we need 5 years.
I just have to say my one little point. This is State Farm that is arguing this. So this is the position of the State Farm Corporation that this is how it feels it should treat its insured.
Your Honors, it's certainly State Farm's position that its insured have to comply with the statute of limitations provisions as set forth by the legislature in order to have a viable claim. And remember, we're only talking about the claims that are filed beyond 1 year, which is the limit that the legislature set.
Thank you. I have no other questions.
During the questioning from Justice Bernstein, I had a chance to revisit the briefs. Your brief says that the mom called a State Farm representative.
Yes.
Plaintiff's brief says mom called the State Farm agent, her agent, and that at the deposition of Dillon, it was established that that agent put it in writing and forwarded it to Dillon. Are you telling me that theirs is an inaccurate statement of the facts, or are they both accurate? You just chose to, in your brief, to be more brief or less specific?
Your Honor, my understanding was that the call was made to a State Farm claims representative. If it was made to an agent, I don't think it changes the analysis one bit, because either way, these are State Farm authorized agents. The call was made. The whole purpose of that call is because I'm calling my insurance company.
Again, I was really curious why the briefs didn't talk about who the agent represents. And I took it from you, it's because they never called the agent, the person with whom the insured deals with. But when I read plaintiff's brief, I got the sense that plaintiff did in fact call her agent, which then triggers in my mind, who do you work for?
And I can just answer honestly that the reason I didn't address that in my brief is because nobody has argued that it makes any difference under the statute. Either way, these are State Farm people that she is calling. So the notice is given, the oral notice is given to a State Farm representative. What happens internal in State Farm doesn't.
Well, just, all right.
That's my position.
We're not going to
That's
go
why I
anywhere
did-
further with it. I get it.
Okay, thank you, Mr. Hudson.
Thank you, Your Honor.
Good afternoon, Your Honors. Patrick Richards appearing on behalf of Jessica Dillon. Also here is co-counsel who helped try the case, Dan Iacco. As most people would probably say in my position, I think the Court of Appeals got this case right. But I think our position in the Court of Appeals opinion is further buttressed by the Perkovic versus Zurich decision that was just recently issued. That decision reiterates that to discover the intent of the legislature, you need to look at the clear and unambiguous language of the statute. And that's what we have here, is we have clear and unambiguous language in the statute. And our position is that Ms. Dillon complied with every technical aspect. To be clear, we are not making the argument that plaintiff substantially complied with the statute. We're saying she, in fact, complied with the statute. She provided written notice. It was provided on her behalf. And she gave notice of physical injuries, which is all that is required under the statute to the defendant. We were asked by this Court to address two issues: the specificity of that notice and whether or not written notice was provided on her behalf. I'm prepared to go into those two, but I would waive any free fire zone that's remaining before I start. But I would start, as you did, with whether or not written notice was provided. It is our position that it was. And
what is the evidence that this notice that came from within State Farm was on her behalf?
Correct. To understand it, I think you have to look at the timeline. And I completely disagree with his characterization of the facts. Now, he was not the trial attorney, so perhaps he wasn't there for discovery. But the way this went is that there was contact between the Dillons and their agent, Lemansky, which is noted in Exhibit A of our brief. The information was provided to that agent. That agent gave that information to State Farm. It was recorded into the claim file. And you see that where it talks about the time and the place and the
No, I get it. But Lemansky's got a job to do. And
Right.
Is he doing that job on behalf of the insured, or is he doing that job for State Farm? Because State Farm will say anytime you hear any notice or any reason to think that a claim is going to be coming, you better put something in the file. We want everything documented. So the question remains, what evidence is it that this was done on her behalf?
Well, what would the reason be if it was not done on her behalf, if it wasn't to set up and establish a claim? When you provide your information, this case went down like almost every other case does in the state of Michigan when somebody's injured. You make the call to either your agent or the insurance company, and you report the claim. They take the information in. They recorded it into the claim file. That's the writing. The claim file that we attach as Exhibit A has all the required elements.
So you agree with opposing counsel, doesn't matter whether the call went to the agent, to a claims representative, to an adjuster, anybody at State Farm, when you call and describe the injury, you're done as long as that person puts it in writing at State Farm.
Well, I don't know that I agree with that, because in this case, not only was there contact with the agent, 3 days later there was contact between the mother of the plaintiff and the claims adjuster, Denise Pierce. And that's where the additional information on September 19th is recorded, where there's questions about why did they wait till the September 19th to report it, and there's information that they waited because they were trying to get medical bills. There was more information about the nature of the injury, describing the road rash, the back injury, the shoulder. There was additional information about how the accident happened, that it was blunt force trauma, that she was thrown up on the hood. So all of that was recorded by the adjuster, and there was 3 days earlier there had been information recorded by the agent into the claim file. The statute says nothing about who has to provide the notice. It just says it has to be provided on their behalf. There's no particular limitation that it can't be the agent or the adjuster.
Isn't one of the purposes of requiring written notice precisely to avoid disputes and controversies concerning what exactly has been presented to the insurer? Sometime down the line, when you have litigation, as we do here, if there's been written notice, there's really not much wiggle room for disagreement and dispute. You look at the written notice, and that generally would speak for itself. We have a circumstance, though, in which the written notice, if there was in fact any such notice, was basically attributable to somebody who works for State Farm. Are they going to be the kind of people in the future, if there's a dispute that arises out of this case, that you, representing the plaintiffs, are going to say, yes, we're confident that the appraiser at State Farm or the agent at State Farm or the claims representative at State Farm got it right? Aren't they kind of in an adversarial situation with you in the sense that it defeats the purpose of written notice? The purpose of written notice, again, is to ensure that there is just not much room for dispute when in those cases a dispute arises at some later time.
Well, two things. I think this notice provision is different than other notice provisions like the highway defect notice, where that's required by, it says specifically that the injured person has to give the notice, and it's very detailed about what the notice has to include. This notice provision isn't like that. It's much more general, and it allows for the notice to be given by anybody
What's the
on the
purpose of
behalf.
comparing it to other notice provisions? I'm asking you specifically, isn't that a legitimate explanation for why the legislature would have a written notice provision here? And if so, isn't that somewhat compromised or defeated by the idea that the written notice, as it were, comes from somebody working from at State Farm and not from the plaintiff or a legitimate agent of the plaintiff?
I would say no. I don't think the statute requires that. You may be asking what is best practices, and if I were to advise somebody, I would say, look, don't rely on what your agent or the adjuster put down. You make sure you're
I'm not
specific.
talking about best practices. I'm talking about why written notice would be required.
Well, it's to give them notice of the claim, and you look to the language of the statute, and here it just says notice of injury. And it says that the notice can be provided on that individual's behalf. And it has to be written, and we have it written. Now, yes, she is now at their mercy that they recorded it as she provided it, but I don't see how the fact that they provided.
Well, that's the whole point. She wouldn't be at their mercy if she had written something herself. She could rely on that written notice. She wouldn't be at anyone's mercy, to use your term.
Yeah, but the statute specifically says she doesn't have to write it herself. It can be written on her behalf. And there's no restriction that can't be an agent or an adjuster.
I guess if the agent is actually an agent of the insured, I have no question in my mind that that notice is being provided on behalf of the insured. But if what the agent is doing is operating for State Farm, I'm a little bit at a loss to conclude it's being done on behalf of the insured.
Well, and I guess that the agent, whether the agent was an independent agent or a State Farm agent, that never came up because this issue never came up until after they asked for application to leave to this court. It really was, the issue was always about that the notice didn't contain the word HIP. There was never a fight over whether or not written notice was in the file. They had written notice. They got it from the agent. Her mother called in and gave them the information, and it was memorialized in the claim file by the adjuster. They acted on that notice. They sent out a letter and said to Jessica, we have opened your file. Please sign this medical authorization to continue if you're going to make a first-party claim. She signed the authorization and returned it. There was never an issue. They never said we need additional information or we don't have what's required. We don't have the specific nature of your injury. That never came. And they want to point to the fact that the Dillons didn't come back, but the reason they didn't come back is because State Farm incorrectly told them to look to their health insurance carrier. That turned out to be false, too. They weren't supposed to look to their health insurance carrier. They were supposed to look to State Farm all the time. So State Farm doesn't have clean hands here in this respect. They took in the claim. They never said they didn't have the information they needed. They, in fact, sent a letter out acknowledging, said, we have received your claim. And then the case had this unusual twist where we discover a hip labrum, which was, undiagnosed for several years. It was confused with the back injury, but eventually diagnosed. And that kind of leads us into this whole notice of injury versus notice of the injury.
So can we talk about that? So the Court of Appeals was pretty broad in its holding. The Court of Appeals basically said if you give notice that you were injured somehow, that's good enough. Your client gave notice that's more specific than that, but the question is it specific enough? So is saying, I assume that you wouldn't think if I said my shoulder is hurt, that's good enough to give notice of a hip injury. Is that right?
That would be my backup argument. But I
Your
would first
backup
argue
argument.
that...
So what about, well, let's hear what your first argument is.
My first argument is it just says notice of injury. It doesn't say notice of the
It says the
injury.
nature of the injury.
Right, but the nature to me and to the Court of Appeals, as the Court of Appeals pointed out, is more of a general phrase talking about the basic fact that you have
That
an
you were
injury.
injured?
Yes, that you're injured.
Nature of the injury is just, or nature of injury is just, I was injured?
My concern here, and I think, and the Court of Appeals pointed this out, is that, and I think some of the questions earlier reflected this, is that if we get into this, that you're going to have to name, as I think the amicus brief said, a specific body part to comply to give the nature of the injury, then we're going to get into this hair-splitting
It's not
contest.
the nature of the injury, it's the nature of his injury, right?
Right.
Nature of injury, I think.
So are we going to, have to split hairs about when you say a leg injury, does that include the knee?
Yeah, okay, so, right, there might be some line drawing problems. So there's two ends of a spectrum. One is you could just say, I'm injured,
Right.
and that'd be good enough. Or the other end of the spectrum is you could say something very specific that you'd have to get in an anatomy book to look at. Or there's something that, like, yeah, you're close enough. And so the question is, what's your best argument? Let's say we're inclined towards that. What's your best argument that this is close enough?
Close enough would be that there is expert medical testimony at the time of trial by Dr. Austin that the torn hip labrum, that injury, can manifest itself as low back injury, and it does so quite often, that it can come on over a period of time. The medical evidence that the jury accepted is that the injury was traumatic. It is related to the accident. We're not talking about an injury here that wasn't accident-related. It has been established it was accident-related. And the fact that she wasn't able to specifically identify that it was something internal in her hip, that it was the torn hip labrum that was causing her back pain, it would seem that would be unfair if she gave them injury of the low back, and that would be enough to cover the hip injury.
So as a bright line rule, if you're describing the symptoms that arise from the injury you received in the accident, and later those symptoms can be traced to the actual injury that may not have been apparent, you're saying that would be sufficient?
Well, I guess that's why I don't even know that we should have a bright line rule. I think that's why they left it with that general notice of injury, because that's what we get into, is that there'll be all kinds of litigation now about whether or not, when you said back, was that enough? Are you feeling referred pain into your hip, or was it something completely separate?
It says written notice of injury as provided herein.
Correct.
And then it goes on and refers to the time, place, and nature of his injury.
Correct.
So it's more than just notice of injury. Notice of injury is provided herein. So there has to be some detail. I'll be frank with you. I think the Court of Appeals made it far too easy. The question for me is whether your notice was sufficient under whatever the proper standard should be. I think the Court of Appeals got it wrong as to what it takes. Just saying that you were injured alone is essentially the way I read the Court of Appeals, and I don't think that's accurate.
Well, I think my position is she identified the injuries she knew about at the time she gave notice. To try to put on her that she has to predict everything that's going to happen in the future is unfair. I don't think that's what the statute intended.
It's a good argument.
She gave the injuries that she knew about. And ultimately, State Farm is protected by the arising out of language. They raise this issue that if you complain about a toe when your initial notice, and then 2 years later you say you have an elbow injury, that's that's not going to, that's going to be unfair to them. My position is, why shouldn't that elbow be covered if it happened in the accident? But you're still going to have to prove that it happened in the accident. We can't just start picking body parts 2 years, 3 years down the road. I have to have medical testimony, expert testimony, that this actually was caused by the accident. So they're always going to have that protection, and that's a very high burden. This notice is just, for lay people to get their claim opened. It's not, generally attorneys aren't even involved in this process.
But as you would construe the statute, lay people could get their claim open just by saying, I was hurt. That would do it. I was hurt.
No, I think that they should give, as best they can, the nature of the injuries that they know about.
Well, the Court of Appeals said they only had to say, I was hurt.
I think
So
they
you
said
wanna-
physical injuries, correct.
Okay, I was hurt. I was physically hurt,
Right.
as opposed to emotionally hurt or economically hurt.
Well, I'm not going to argue with the Court of Appeals, but I believe that you should at least give the injuries that you know about. Otherwise, I think it's unfair for me to try to predict whether or not through physical therapy, because I have a crushed pelvis, that I'm also going to have all these other problems, that I'm going to have a problem with my knee because I walk differently, and now I have. How am I going to know all that's going to happen?
Thank you, Mr. Richard.
Thank you.
Appreciate it. Case is submitted.